it's kind of really confusing on who is to be served. I can tell you who I served.
It's okay, I'm just inquiring.
I have filed an order appointing counsel. I don't feel it's relevant for me to go into issues when I have not been afforded the opportunity for an attorney.
Let me just try to frame why we're here this morning. You filed a motion for appointment of counsel and a proposed order appointing counsel, as well as a calendar note. And you filed some exhibits in support of your motion. So I have received all of those and I reviewed all of those. I'm going to pause for a moment to complete the order in another matter that I just heard.
Here's Mr. Richardson.
Oh, I'm Mr. Richardson.
Did you want to review the order, Mr. Richardson?
You don't even want to know what I want to do here. Where's this order?
I handed it for everyone to say.
No, I was going to see no more.
I would gladly step out of the way to give him an opportunity.
Give me a moment to review the proposal in another matter. That's all I need. So, Mr. Richardson and Ms. Stanton, the order that I've just signed reads, the defendant's motion to dismiss is denied. The court declines to address the interest issue addressed in Mr. Richardson's motion. It is not properly before this court on a civil motion. The court defers to the trial court judge or arbitrator.
Thank you.
And I can sign that. And Mr. Richardson, if you'd like to review this and sign it, you are invited to do so. Ms. Shevlik, thank you for pausing. Oh, and I see someone has set up a recording device. I suppose for the benefit of the record, I'll indicate that the court received through my law clerk an email that was sent to other judicial officers indicating an intention to record this morning's proceedings. Typically, before an individual begins recording, they ask for permission and receive that permission before actually starting. Are you recording now, sir?
Yes, ma'am.
All right. I would, in the future, prefer that individuals request for permission and receive it before actually starting. It's the court's intention to permit the recording. It's not an official recording of the proceedings, but I don't want to interfere with Ms. Shavlik's ability to address the matter before the court. So Ms. Shavlik, going back to the procedural status here, I just want to address a few things with you before we get to the merits, okay? First of all, you filed this motion under a criminal cause number, which may or may not be precisely the right way to go about things. And I bring that up only because the criminal case is assigned to Judge Weiss. It's pre-assigned to Judge Weiss. This is not a separate proceeding. So when I received these materials, I wondered whether or not it would be appropriate for a judge other than Judge Weiss to hear this. So that's just one issue that I contemplated. Another issue that I want to address with you is, you indicated when I called the case after you had entered the courtroom, you had noted this before Judge Dingledye. Judge Dingledye is not available to hear civil motions today, which is why I'm hearing civil motions.
She was on the calendar when we noted it.
But that's accurate. And so I don't know whether it's your decision or preference for me to hear the matter. I am confident that I have the ability to fairly and impartially consider the legal issue here, but I don't know whether you feel the same way.
Well, there are issues pending at the state Supreme Court regarding Dawson case. And you contributed $300,000 to that agency. And so there is that case that's pending, and that is very relevant. When I noted this, and we sent in our GR-16 notice, we were unaware at the moment that you, Judge Janice Ellis, was going to be the civil motions judge, or you might have made some other arrangements. We weren't given any notice. Let me finish for the record. And
sure.
You had addressed some sort of issue regarding the way that I filed my the calendar note and the motion and the order after the order, the order that we expect the way for the assigned counsel, is that the order to show cause hearing was filed in the John Ray case, which is the most bizarre situation that I've ever come across, because I had no appeal rights as far as like you said, it was filed in a criminal case when there's, obviously I wasn't a party in the case. So I asked, when I got the order to show cause, I filed a motion to have a counsel assigned. So when someone's accused of a crime or a potential crime, or faces a potential to having served jail or any criminal other accusation, they have a right to give them Miranda's rights and a right for an attorney. Well, in this case, Judge Wise filed an order to show cause, ordering me in the court to produce my media shield protected pictures to him. Well, of course, the first thing I did is I want an attorney. I don't want to face any kind of defense or go into any kind of legal defense for myself until I receive an attorney. That's the first thing. He ignored it. He ignored my request for an attorney. He held a hearing without me. And by the way, I wasn't even properly served. They put it in the mail. So when somebody's brought into a case or summoned, they're usually personally served, or they become aware of it personally. This was dropped in the mail 3 days. I had 3 days notice. Didn't have an opportunity to get an attorney. So I was ignored. Judge Wise did not ignore it. He held a hearing, had the prosecutor testify, had other victim support services testify. Their testimony is uncredible. It was not true. The pictures that I have myself, would contradict that. But I'm not going to defend any of those things until I have an attorney. And I think it's improper for the law to say, you're guilty, we're not going to give you an attorney, we're not going to give you an opportunity to respond. And by the way, Judge Wise says, I have to apologize to the court, or I'm going to be facing commitment or confinement.